You failed to prove your case against DSS, court says to Nnamdi Kanu. A federal high court in Abuja on Monday dismissed a 1 billion naira suit filed by Nnamdi Kanu, the detained leader of the proscribed indigenous people of Biafra, Ipob, against the federal government and Department of State Services, DSS. Justice James Omotosho, in a judgment, held that Kanu failed to provide credible evidence to back his alleged violation of his fundamental rights by the DSS and its DG, Yusuf Bichi. I have gone through the evidence laid before this court, and there is nothing placed by the applicant Kanu to show that indeed the third and fourth respondents, DSS and DG, prevented him from seeing his counsel, or that they prevented the counsel from taking notes, or that they eavesdropped on their conversations. The applicant only stated that he believes these facts to be true without any proof of such belief. There are no dates or specific details as to when any of these occurred. There is also no evidence of any specific information which the third and fourth respondent gleaned from the conversations which the applicant can prove. Perhaps, if the applicant was able to pinpoint a particular information he gave his lawyers, which the third and fourth respondent used against him, it would have helped his case, Justice Omotosho said. The news agency of Nigeria, NAN, reports that the Ipob leader, through his lawyer Aloy Ejimako, had sued the Federal Republic of Nigeria, FRN, Attorney General of the Federation, AGF, DSS and its DG as first to fourth respondent respectively. In the originating summons marked FHC ABG CS 1633-2023, date and filed December 4, 2023, Kanu prayed for 8 reliefs. He sought a declaration that the respondent's act of forcible seizure and photocopying of confidential legal documents pertaining to facilitating the preparation of his defense which were brought to him at the respondent's detention facility by his lawyers amounted to denial of his right to be defended by legal practitioners of his own choice. He sought a declaration that the respondent's act of preventing his counsel from taking notes of details of counsel's professionals, discussions, consultations with him at DSS detention was unlawful. He also sought a declaration that the respondent's act of preventing his counsel from taking notes of details of counsel's professional consultations with him at DSS detention was also unlawful. Kanu therefore sought an order of injunction restraining and prohibiting the respondents from their act of forcible seizure and photocopying of confidential legal documents brought to him at the detention facility by his lawyers. But in a counter affidavit dated and filed by the DSS on March 12th, the security outfit denied allegations leveled against it. In the application deposed to by Yamuje Benye, a legal department staff, he said 11 paragraphs in Kanu's affidavit were untrue. He averred that Kanu was in safe and secured custody of the DSS and he is not detained in solitary confinement. According to Benye, the applicant is allowed access to his family members and team of lawyers on his visiting day without any hindrance whatsoever. He averred that Justice Bint Ayako of his sister court, who is presiding over Kanu's criminal trial, had always maintained that a visit to him should always be under supervision, as it is the best practice all over the world. The judge equally observed a letter from the DSS to the lead lawyer to Kanu, Mr. Aloy Ejimako, stating that the right of counsel to consult with the applicant was unhindered. Also that communication between the counsel and the applicant will continue to be confidential, personal and without interference. This court thinks these exhibits show clearly that the allegations made by the applicant has been refuted by the third and fourth respondent. There is no evidence of communication being hindered or intercepted by the third and fourth respondent, or that they were prevented from taking notes when they consulted with the applicant. Thus, the final reliefs cannot be granted, and in final analysis, there is no credible proof of breach of fundamental rights of the applicant. Consequently, the applicant's application is hereby dismissed, the judge declared. The truth of the matter is that Nnamdi Kanu is using an incompetent lawyer. When Mike Ozome handled his case, everything went well. There are minor cases for Nnamdi Kanu's lawyer to handle his case needed an experienced senior advocate of Nigeria. Barrister Ejimofor cannot withstand against federal senior lawyers. It is frustrating practicing law in a lawless country like Nigeria. To gather evidence in the lawless country is very difficult. Take, for instance, gathering evidence in a military checkpoint where they are brutalizing a civilian through video recording is at the risk of your life. We are caged, and that is why this man is fighting for our freedom. Anyway, guys, please stay informed of the news for today. Don't forget to lay your views in the comment section. Thank you.